Good morning, good afternoon, and good evening for all of those who are listening to this SRHM podcast. I'm Eszter Kismodi, Chief Executive of Sexual and Reproductive Health Matters, and I am very pleased to welcome here our guest today, Deepika Jain from India, Alan Malache from Kenya, sitting right now, I believe, in Washington, and Mindy Roseman joining us from the US. This podcast on rights and evidence-based knowledge in legal action is part of a rights-based knowledge production series that SRHM is putting forward in the form of articles and other knowledge products through podcasts and blog series. These products include, for example, a guide to rights-based knowledge creation, a podcast on key concept, a webinar on accountability, and there will be also an upcoming podcast on decolonization of knowledge creation. We, in this conversation, coming to this discussion from a common understanding that rights and evidence-based knowledge is power, and it's being used and being a fundamental core aspect of the sexual and reproductive health and rights movement. We also understand that we are in a world today in different global, regional, local, community-based spaces when there are various challenges that threaten to turn back progress in securing the sexual and reproductive health and rights of current and future generation. We also have a common understanding that the political environment is such as that it has generated strong anti-gender and anti-sexual and reproductive health and rights movements that challenges basic sexual and reproductive rights, such as rights to decision-making and autonomy in relation to accessing abortion, promote the criminalization of reproduction and sexuality, limit choices related to sexuality, gender expression, access to contraception, reproductive technologies, questions the legitimacy of comprehensive sexuality education across the world, and allow discriminatory practices such as forced sterilization, conversion therapies, and criminalization of our sexuality and reproductive choices. All of these topics will come up in this conversation. And I'm moving now to our guest speakers with a first round of questions. How, based on your experience, knowledge, and participation in the SRHR movement in various spaces and places you are in, influences the use of evidence in legal action? And I'm turning to you, Deepika, first. You are a professor and vice dean and director of the Center for Justice, Law and Society in the Jindal Global Law School. Welcome in our conversation. How do you see the role of evidence and in the SRHR movement from a perspective where you sit in?
Good evening and good morning, everyone. Thank you so much, Eszter, for inviting me into this conversation. It is an honor to be in conversation with Mindy and Alan on this issue. In the realm of sexual and reproductive health and rights, evidence serves as a cornerstone of effective litigation and advocacy. It forms the foundation upon which legal arguments are constructed and decisions are rendered. Given the deeply political and polarized nature of sexual and reproductive health and rights issues, evidence not only supports legal claims, but also shapes the broader narrative that influences judicial decisions and public opinion. The types of evidence that have been used in such cases include medical records, expert testimonials, statistical data, qualitative research, and personal testimonials. Each type of evidence plays a unique role in supporting legal arguments, ultimately determining the outcome. I will highlight very briefly three important aspects that are important for evidence generation in this context. First, Social science and multidisciplinary empirical research is very important, offering insights into the societal implications of legal decisions. For instance, empirical data on maternal mortality rates and lack of access to quality and affordable healthcare have been pivotal in legal arguments for policy reforms. Such data highlights the real world consequences of restrictive legal frameworks, making a compelling case for change. For example, when advocating for decriminalization of abortion, it is essential to demonstrate how laws harm pregnant persons, their families, healthcare providers, and impede access to safe and legal abortion services. Constitutional and human rights arguments then can support this evidence, making a strong case for centering decisional autonomy of the pregnant person while addressing the diverse needs of various groups affected by laws. Let me take another example of evidence submitted before the Supreme Court of Colombia, which highlighted approximately 3,000 women that were facing prosecution in Colombia. Now, this evidence was instrumental in influencing judicial reforms on abortion laws in this country. Similarly, a study on women incarcerated under Nepal's criminal abortion laws provided critical evidence in 1997, where it was found out that 80 cases of abortion were reported to police. This was, in fact, published as a peer review article in Reproductive Health Matters. The volume and diversity of evidence presented allowed the courts to gain a comprehensive understanding of the systemic issues, demonstrating need for legal reforms. In line with this evidence generation, it is really important, second, to look at public opinion. Public opinion can significantly influence judicial decisions, especially when it demonstrates broad societal support for SRHR issues. For example, let me again go back to Colombia. There was a public polling conducted in 2017 in 31 capital cities of Colombia, which revealed a favorable public perception of women's reproductive autonomy and a general rejection of criminalization. Finally, grassroots support, built through community involvement, is crucial for sustaining momentum and protecting legal gains over time. Therefore, the legal strategies and evidence generation have to reflect the realities and needs of diverse groups. It is vital to center the voices of marginalized communities, such as people of color, caste marginalized persons, trans and gender diverse persons, persons with disabilities, among others, in the advocacy process. These groups often face unique challenges in accessing reproductive healthcare, including geographical barriers, lack of affordable healthcare services, discrimination, and stigma.
Thank you, Deepika. Now turning to Alan Maleche, who is the Executive Director of Kenya Legal and Ethical Issues Network on HIV and AIDS. Hello, Alan.
Hello.
We have been working now for many years together. You have been very active in the global space of challenging human rights standards regionally in Africa and leading legal and human rights action in Kenya, working with different movements. How do you see the use of evidence in your legal action, whether it's at the local space or in a global space? How do you see the use of evidence in legal action, Alan?
Thank you so much for having me here, Eszter, and thank you to my fellow podcast members, Deepika and Mindy. It's a good conversation, and I just want to build up from what Deepika has spoken about, because what she's spoken about resonates to how Kaelin approaches this conversation of using evidence for legal and human rights sexual reproductive health rights actions. I think for us, what we have learned over a period of time from litigating and doing legal and policy advocacy is that data is extremely pivotal in legal and policy advocacy, especially in guiding reforms and also shaping court cases. And in terms of guiding reforms, we have realized that quantitative data like statistics on health outcomes, say how many women are accessing post-abortal care, is extremely important to be able to highlight the impact of certain laws and regulations that may limit people from accessing safe abortion. And then on the other hand, qualitative data, such as the personal testimonies of either healthcare workers who are arrested by police officers for offering safe abortions, or actual women who are arrested and frog-marched to police stations while they are bleeding for seeking to procure a safe abortion from a healthcare worker, all play crucial roles in terms of shaping the thoughts, the arguments, and the ability to convince the judiciaries, lawmakers, policymakers on why they need to make certain important cases. So I've given the case of post-abortal care and access to abortion, but this has also applied in the case that we worked on addressing the issue of forced and coerced sterilization of women living with HIV in Kenya, where we were able to work with partners to collect the lived experiences of 40 women who are living with HIV and demonstrate how the health system was disadvantageous to them, denying them an ability to make an informed choice as to whether they wanted to have a permanent form of family planning or not. And by documenting these particular stories, we are able to demonstrate the systematic failures of the health system. And this report, which was certified by a local research institute or a local IRB, was also used as part of the evidence in our landmark court decision that was able to be the first in the world to be able to come to terms that a woman can be discriminated on the basis of her HIV and subjected to forced and coerced sterilization. And so it's important for us to continue collecting this data, but we must also appreciate that there are challenges in getting this data, in ensuring that the evidence is comprehensive and addressing any data gaps, and the effective use of evidence definitely can directly impact legal outcomes and drive policy changes by highlighting critical issues and supporting arguments for reform. So we strongly continue to use evidence and collect evidence and try to use that evidence to shape the legal and policy arguments.
Thank you, Alan. Mindy, I'm turning to you. Mindy Roseman is the director of the International Law Program and director of the Gruber Program for Global Justice and Women's Rights at Yale University. Mindy, we know each other for, I think, 25 years now. You have been working at the international space and now actively involved also in US advocacy on different sexual and reproductive rights issues. How do you see that evidence plays a role in international standards development, and where do you see the opportunities? What is your experience with these opportunities?
Thank you, Eszter, and Sexual and Reproductive Health Matters for the podcast forum, and it's wonderful to be in conversation. I thought Deepika really set out a good context for both what Alan had given as examples and what I'd like to speak to, as you said, about the evidence that we've used to influence the development and content of international human rights standards. I'm going to speak specifically about the Human Rights Committee General Comment 36 on the right to life, which focused on a broad range of issues, but included paragraphs related to what governments must do to ensure that the right to life of pregnant persons was protected, and they spoke expressly about abortion. So the committee, it's an independent expert body that sets standards for governments through general comments that explains to governments what they must do to meet and apply the rights contained within that convention to their national laws and policies and so forth. In order to develop these general comments, they solicit input from state parties, from other experts, and civil society. In preparation for General Comment 36, organizations such as the Center for Reproductive Rights, UNFPA, people like me affiliated with universities, submitted statements outlining the evidence on how laws that restricted abortion access increased maternal mortality and morbidity. Right? So in tension with the idea of the right to life, Now, of course, there were also plenty of NGOs and governments that claimed they needed to criminalize abortion as a way to promote the right to life of the fetus, something that we know isn't recognized as a matter of international law. But in all events, on balance, sifting through all of this evidence, it would be nearly impossible to square any state's criminal abortion law with its obligation to protect the life of its pregnant residents. The general comment that resulted from this process, while it certainly could have been stronger, it reflected the evidence presented. And it states, among other things, and I'll quote, that restrictions on the ability of women or girls to seek abortion must not, inter alia, jeopardize their lives, unquote. And it questions strongly whether criminal law is ever appropriate to regulate this area. So why is this important? Well, having this standard, it's a powerful tool for advocates to use with their governments, legislators, the media, popular society at large, to reform restrictive laws and to advocate to improve access to services. If those states and societies value their commitments to and the content of human rights. The Covenant on Civil and Political Rights is one of the most widely ratified human rights treaties. So having this general comment is incredibly important. Having the details that were bolstered by the evidence that the whole SRHR community was able to deliver to the committee was really vital. I was extremely gratified to be part of the process. Having a journal like SRHM, which carried commentary about General Comment 36, was extremely valuable.
Thank you, Mindy. And as you are speaking, I'm just reflecting on the development of many general comments with UN treaty monitoring bodies, engaging with other UN agencies for standard development. And I cannot not recognize that what has probably worked 20 years ago is not necessarily working, whether as I see what evidence resonated for parliamentarian action in Hungary or working with UN special rapporteurs, not necessarily working today. For example, we believed that the role of UN special rapporteurs have been always to uphold human rights standards and give rights-based interpretation. This was the case for several, with all special rapporteurs on the right to health. And we will just have to leave with the report, the recent report on the special rapporteur on violence against women, when she not only equals, she calls prostitution to violence, but also misuses evidence and doesn't uphold in her report to human rights standards. That makes me ask the next question to this panel, that how do you see in your legal action, what you are engaging with, that the role of evidence is changing, and as you are engaging with parliaments, with ministries of health, with international bodies, you may need new strategies, you may need new forms of evidence. How do you see the changing role of evidence in legal action? Deepika, I'm turning to you.
Thank you so much, Eszter, for this very important question. The landscape of SRHR is constantly evolving, with new challenges emerging from legislative changes, court rulings, and shifts in public opinion. In this dynamic environment, legal strategies must be adaptable and responsive to ensure that SRHR are both protected and advanced. Adaptable legal strategies are those that can swiftly respond to new threats or opportunities. This requires a deep understanding of the legal, cultural, and political context, as well as the ability to mobilize resources and allies quickly. For example, in the face of growing opposition to reproductive rights in many countries, including India, legal strategies have to be innovative, find new ways to frame and argue for these rights. The language of human rights, traditionally a powerful tool for advancing reproductive decisional autonomy, is increasingly being co-opted by anti-rights groups. These groups, often opposed to gender equality and bodily autonomy, have started to creatively use human rights rhetoric to argue against reproductive freedoms. by framing their opposition in terms of protecting life or, quote unquote, defending the family. They cloak regressive agendas in the language of rights and morality. This usurpation not only undermines genuine human rights advocacy, but also poses a significant threat to reproductive justice. Therefore, advocates may then need to rely on evidence generation, make it more creative, leverage international human rights law, develop new and creative constitutional arguments, and most importantly, map the strategies of opposition groups. For instance, the media can play a very important role in this process, and incorporating testimonials from the most affected persons can bring a powerful human element to courtroom narratives. By anticipating and counteracting the tactics of those who seek to restrict reproductive rights, advocates can stay a step ahead in these legal battles. Finally, adaptable legal strategies must be inclusive and intersectional. Reproductive rights and sexual rights encompass more than just access to abortion or contraception. They involve broader issues of decisional bodily autonomy, gender equality, sexual rights, and social justice. Legal strategies that incorporate these broader perspectives are more likely to resonate with diverse groups and build a stronger, more unified movement. Recognizing and addressing the interconnectedness of these issues ensures that legal advocacy is not only effective, but also reflective of the needs and rights of all individuals. As the landscape continues to shift, the importance of adapting legal strategies to incorporating diverse forms of evidence and knowledge will remain crucial for advancing rights and achieving equitable outcomes.
Thank you, Deepika. Alan, how do you see the changing nature and evolution of evidence? And do you see any global and regional trends, how evidence can be used strategically and what kind of evidence we need?
Thank you so much, Eszter, for another very important question. Indeed, a lot of evolution that's going on with evidence, and evidence in the legal and policy context has greatly evolved from the basic data collection that we do to very sophisticated methods, including digital tools and data analytics that is happening. And so we have seen situations where this advancement has enabled more precise and actionable insight, which is very crucial in most litigation and advocacy that we do on matters relating to sexual reproductive health and rights. For instance, we've at Kelin seen the use of using phones and mobile apps for people to report cases of stockouts of contraceptives, for people to report when human rights violations are happening. And some of this information is then collected on a central portal, and someone is able to analyze that information to help demonstrate if something is systematic, to help provide a rapid response if one is needed in a particular situation. And some of this evolution of data collection techniques have helped strengthen legal arguments, policy arguments by providing robust data-driven evidence that can effectively be used in court or even in boardrooms to challenge what Deepika has rightfully spoke about on the issue of the opposition and their rights claims that are brought forward by the anti-rights movement. So we see this evolution, and coming to the global and regional trends, I think I must say we need to appreciate the fact that there is a great push currently for community-generated evidence through participatory action research. This need is increasing, and in a current project we are working on that is looking at how the use of digital technology affects the ability of young people in Kenya, Ghana, Colombia, and Vietnam to be able to access sexual reproductive health services and information. We have received vital information around what are their insights as young people on using the apps, what are the insights in terms of the human rights violations they face. And through the research that we are doing, we've then been able to flesh out information that is helping some of our policy recommendations to both WHO, to the ministries of health in the respective countries, to the regional bodies, and even to civil society. But we're also seeing evidence that's coming from these conversations that would be able to inform future litigation in terms of how the affected communities are being affected by the anti-rights movement, but also by the shrinking space of civil society. And then there's also a trend where it's no longer top-down approach, whereby it's the global bodies dictating what needs to happen at the grassroots level. But we're also seeing a shift in the evolution that there's a lot of voice coming where the lived experience at the grassroots level is actually being used and adapted to be able to inform the changes that need to happen at the global and regional levels. And I think this way of working then promotes the rights-based approach where it's participatory, where it involves all people, and it's not just a top-down approach. So I think it's important for us to recognize these changing trends. It's important for us, especially in this day and age of time, to be very alive to ensure that evidence that is collected remains compelling and effective in countering misinformation and supporting the robust legal strategies. Back to you, Eszter.
Thank you, Alan. And as you are talking, I just wanted to remind the listeners that all Deepika, Mindy, and Alan are part of the SRHR family, whether Mindy is an associate editor, Alan is in the editorial advisory board, Deepika is part of the steering committee of the regional hub of SRHM and the global collaborator. And we are working hard at how in the SRHM journal can create articles and resources, stretch the boundaries of evidence and power that exists in the evidence creation world, so that the communities and the voices of the communities are considered to be evidence as well. And we have a decolonial approach to evidence that will be the part of the next podcast. And now I'm turning to you, Mindy, that where you are sitting in a space when the unthinkable happened, and despite of all available evidence and human rights standards, reproductive rights were taken away in the US. So what's happening, Mindy, with all the evidence that would not allow to such an action to happen in a democratic society? What's happening with the evidence in the context of abortion rights in the US?
Yeah, indeed. I do just want to add a small clarification. You know, the Supreme Court in overturning Roe threw everything back to the states. So plenty of states within the United States have even strengthened access to abortion and legislated shield laws to protect healthcare providers that are resident in their state who may be providing care to people who come from outside of the state or through telemedicine. So yes, there are many states which have regressed in terms of across a range of sexual and reproductive rights issues, abortion just one. But there are some bright spots in the United States. So what I want to do in answering your question is to pick up a little bit on what Deepika and Alan were speaking to about, on the one hand, needing creative strategies, and the other, the resurgence of a very conservative, heteronormative notion of reproduction and sexuality and gender. And the need for the movement in the United States, I think, to regroup, or at least parts of the movement in the United States, which were so fundamental in using court-based strategies to secure reproductive rights, to think more politically. Because what happened in the United States at the Supreme Court didn't happen in a vacuum. For Roe to be overturned, the politics behind the appointment of Supreme Court justices had to shift. It was a long-term project due to former President Trump's ability to appoint 3 justices to the Supreme Court who were in favor of overturning Roe. It really hung by a thread, the constitutional rights and the legal fabric supporting access to abortion in the United States was very thin indeed. So what the majority in Dobbs did was they cherry-picked historical facts to make an argument that the right to abortion is not in the U.S. Constitution. It was found in Roe to be part of the right to privacy, which also is not expressly written into the U.S. Constitution. The right to privacy itself was an interpretation of something in the due process clause, a notion of substantive due process. Well, how do you know what is substantive due process? The idea is, at the time of the founding of the Constitution, there are things that are beyond the pale of the government to prohibit, such as privacy and family life, right? It's an inchoate human rights notion. Well, how do you know that? You have to look to the history and tradition. So the Dobbs majority looked to the history and tradition of the United States and globally to see if there was a right to abortion. And they handpicked historical facts and concocted a story in which abortion was always and forever criminal. And they looked around the world and they said there are just so few countries that allow for liberal access to abortion, and citing among other, like a handful of countries, Canada, North Korea, and China. So all of this was like patently wrong, but here we have this incredibly biased decision that then overturned Roe. But that's not the only thing that's faulty with a court-based strategy to secure constitutional and human rights, particularly related to SRHR, because courts are limited in what their review of laws. Legislatures, they take testimony, gather evidence, data, all kinds of things. We use evidence, and those who oppose us use evidence as well. So the legislative record is just full of evidence. And the legislatures, it goes into a black box, and what comes out is what they decide. And courts are very limited in how they can review what is produced. And so we have in states bans against gender-affirming care. They promote abstinence-only sex education. They've restricted abortion. And there's very little that courts can do, assuming these laws, of course, are challenged. But the political basis for all of this is very much in evidence. So, there's so much I could say and go on about. But what the movement really needs, they need to mobilize in a much more political way and secure rights through political processes.
So, Mindy, you are really leading us to the conclusion of this conversation about how can we be forward-looking and what we need for the human rights movement and legal action. And Mindy, you already stated several actions, and somehow, Alan, you also moved us to that direction. So the last round to Deepika and Alan to have some reflection. So what do we need? What kind of tools, what kind of societal and other action we need to revitalize and use rights and evidence-based knowledge, depending where we are and how the political changes are happening, because all what we can do is always politically contextual. Deepika?
Drawing from Alan and Mindy's comments, I would like to emphasize that in order to effectively leverage evidence in legal and human rights advocacy, it's essential to ensure that evidence is not only strong and credible, but also strategically utilized to create meaningful and lasting change. Evidence generation should be interdisciplinary and rooted in cross-movement solidarity to address interconnectedness of social justice issues. To be truly effective, evidence must be contextualized within legal, cultural, and political environment, as I had said earlier. I also wanted to draw our attention to this very important conversation about the politics of knowledge production. As we know, the production and dissemination of knowledge are also evolving. There is a growing recognition of the importance of interdisciplinary research, indigenous knowledge systems, and minor knowledges, those traditionally marginalized or overlooked. The shift towards more inclusive and diverse forms of knowledge reflects a broader understanding of the need to consider various perspectives in the pursuit of justice. As a result, the range of evidence deemed valuable in legal context is expanding, leading to more comprehensive and equitable legal frameworks, and we must hold on to that and be attentive to the way we produce knowledge. Finally, and most importantly, we must remember that strategic litigation can be a powerful tool for advancing legal and constitutional rights, but it has significant limitations that must be acknowledged. Mindy also alluded to this in her earlier comments. There is a risk that strategic litigation may prioritize legal victories over the needs and voices of affected communities, potentially creating a disconnect between legal strategy and lived realities of those it seeks to help. It is crucial, therefore, for us to ensure that litigation efforts are grounded in the actual experiences and aspirations of the communities involved. Balancing legal approaches with other forms of advocacy that address systemic issues beyond the courtroom is also essential for achieving comprehensive and sustainable change.
Thank you. Over to you, Alan.
Thank you, Eszter, and thank you for the conversation and really a lot of wisdom that has been shared by Mindy and Deepika. I'll just say I've got 4 broad areas that I'll quickly address. The first one is we still have to remember the issue of data quality and accessibility. That is important to be effective in court cases and policy reforms. We must find a way to ensure that the evidence must be robust and reliable. By ensuring that the data is accurate and accessible to all stakeholders, including legal teams, policymakers, is very essential for making strong cases and advocating for effective reform. So this is one of the things we have to continue doing if we want to effectively use of evidence and knowledge to be able to influence SRHR positively. The second one for me is capacity building, especially providing, where possible, training for activists, community-based groups on how they can be able to interpret some of the evidence based on the data that has been collected, and then use that evidence to apply it. And this includes understanding how to present evidence effectively in court and for influencing policy, especially when you're dealing with sometimes what people would see as a complex medical matter in the case of safe abortion, in the case of surrogacy, in the case of IVF, or even in the case of sterilization of women living with HIV. How are you able to build the capacities of lawyers and different players to be able to present that evidence in a manner that is palatable to the judiciary system and in a way that it makes sense? And I think it's important that we secure funding for evidence collection. And this is an important call to funders to see, even as it supports strategic litigation, even as it supports policy reform, whether it's on safe abortion, whether it's on sterilization, whether it's on surrogacy, whether it's in the use of AI in the SRHR space, they need to ensure that there's a steady stream of high quality data that is collected for the necessary legal and advocacy work. And for us to have that steady stream of highly quality data, we definitely need for that to be funded. The third issue for me is collaborating and networking, and Deepika has spoken to this. The interdisciplinary research, the need for academic institutions to partner with civil society and communities, the need for communities to partner with the media, the need for the media to partner with experts, especially experts who understand the law, experts who understand the medicine, will enhance the quality and the scope of evidence that will be collected and communication. So that collaboration is extremely important because it ensures that the evidence is comprehensive, well supported, and this will always be vital for the success of court cases and impact policy advocacy. I want to conclude by saying that when we have all this going on, you have the data quality and its accessibility, you have capacity building, you have collaboration and networking. You then want to ensure that the advocacy and communication is effectively happening. Clear communication of evidence to policy makers and the public is extremely critical if we want to shift any minds. Crafting compelling advocacy messages based on your audience and based on solid evidence will really help in influencing the policy and legal arguments that we make. And this will actually see us to have the necessary reforms to appear more persuasive and more impactful. Thank you for having me, Eszter, and thank you to my fellow panelists. Over.
Thank you very much, Deepika, Alan, and Mindy, for this conversation. That is a direct follow-up to our meeting that SRHM with partners was organizing in Morocco in June 2024. And we are looking forward to more articles, conversations, podcasts, meetings, collaborations, and other actions coming from this direction. Thank you very much, and have a nice day and evening and good night for everyone who have been listening. Thank you for the panelists, and bye-bye.
Thanks for joining us for this insightful conversation. Please check the show notes for a link to the SRHM Journal, which is available online and open access. Follow us on social media and sign up for our newsletter to receive notifications for new publications. If you're enjoying this podcast, please subscribe, give us a rating, or leave a review. Sharing evidence-based and rights-grounded knowledge is our passion, and it's also critical to support the advocacy and actions that need to be taken to improve SRHR for all. We would very much appreciate it. Thank you for supporting the SRHM podcast, which is produced by our staff. The music was composed by Tiber Christian and Salomon Beautond.